Hello, everyone. It's your old Uncle Ed here with a special message for California restorers. I hope everybody had a wonderful Christmas and you're enjoying some time with your family and you're staying healthy and staying safe. I've got some news today that I am not particularly happy about reporting, but I want you to know that coming up on the first of the year, January 1st, 2022, the California Debt Collection Licensing Act takes effect. This act says that anyone who is engaged in the regular business of collecting consumer debts needs to have a license issued by the state of California. People look at this and they say, well, I'm not a debt collector, so this doesn't apply to me. But there's a lot of controversy going on out there with regard to the definitions in this particular act. And I have advised some of my clients to go ahead and apply for this license and to do it immediately. And I'm going to tell you why. The reason that this act was signed into law by the governor is because there's a perception that there's an increase in consumer debt and a perception that there's a correlated increase in abusive tactics by debt collectors going along with it. The state of California has had a Fair Debt Collection Practices Act in place, the Rosenthal Act, for many years. You know, you can't call somebody up at 3 o'clock in the morning and shout profanities at them. But what's new now is that in order to collect a debt, including a debt that is actually owed to the person who is making the communication, or that the Debt Collection Act is required to have a license. And here's what it says. No person shall engage in the business of debt collection in this state without first obtaining a license pursuant to this division. Now, I'm going to put some links down below where you can read the act for yourself. You can make a determination for yourself as to whether or not you think it applies to your business or not. But they purposely worded this in a way that's very, very broad. It captures a lot of different types of businesses. And one thing that kind of caught me by surprise is that a debt collector is someone who in the ordinary course of business regularly on their own behalf or on the behalf of others engages in debt collection. So what does that mean? Creditors who are calling to collect money that is owed to them in the state of California may be subject to this act. Now, there are a whole bunch of different exceptions to the licensing requirement, and we've had the best legal minds in my office looking for some exceptions to try to find some ways to keep restoration contractors out of this. I mean, it's not like we are under-regulated here in the state of California, right? And I am sad to report to you that so far we haven't found a good, solid exception that we believe applies yet. Now, this is kind of in flux still because there are a number of questions that haven't been answered. And this word regularly that's in the statute is a very, very important and controversial part of it. And unfortunately, the state has not defined the word regularly. What does it mean for somebody to be in the business of regularly engaging in debt collection? Well, perhaps what the California courts might do is look to see what some other courts have done when trying to define this word regularly. And what they might do is look to see how federal courts have defined the word regularly with respect to attorneys who are engaged in collections for purposes of the Federal Debt Collection Practices Act. Maybe not, it's just an idea, but this is something they might do. And so the federal courts, when looking at law firms to decide whether or not they're regularly engaged in debt collections, is they will look at the absolute number of debt collection communications that they issue. They'll look at the frequency of the communications. They'll look to see whether or not there are personnel that are assigned specifically for this purpose. And so you could see how this could apply to a number of different types of businesses, especially larger businesses with accounts receivable departments. Now, it appears to me that the state is defining the word debt to mean something that is past due. Unfortunately, most restorers have debts that are past due, that are owed to them because they're waiting for the insurance companies to issue a payment on that. And so that's not necessarily going to be a great way for us to get around it. Now, keep in mind, this only applies in California, and it only applies for debts that are owed by natural persons. In other words, this is consumer debt collection. A business entity is not a natural person, and no debt collector's license is required in order to make collection calls to businesses. Now, the act and the licensing requirement only applies when the debt is for goods or services that are for personal or family or household purposes. But unlike the Fair Debt Collection Practices Act, the DCLA, this new one that's taking effect, applies to people who are collecting money on their own behalf, like I mentioned before. Now, if you have multiple office locations and you are required to get this particular license, you do not need to get one for each individual office. You just need it for your principal place of business. Communications that an entity sends out, if it's engaged in the process of debt collections, must display the license number, the debt collection license number, in at least 12-point type. When you have this license, you have to file reports with the Commissioner of Business Oversight, and those reports are under oath. You also, have to maintain a surety bond. So, in sum, debt collectors, creditors, and even attorneys may fall within the extremely and purposely broad definitions that define debt collection in California. Unless they are falling under one of the specific exemptions, they are going to need to apply for a debt collector's license. The state will allow a debt collector to continue engaging in communications for the purposes of collecting a debt after the license application has been submitted. So I'm going to put some links in the comments here where you can go on and you can read more about this. It's a very complex area of the law. It's a little bit convoluted, but I wouldn't be here talking to you about it today if I didn't think it was pertinent to at least some restorers who are out there. I'm not saying definitively it's required for you, but take a look at the definition and talk to your lawyer about that and come up with a conclusion that makes sense for your business. We've put together a handy little FAQ sheet with some of the bullet points and the key factors to keep in mind about this law. And if you'd like to have a copy of that, just send me an email to ed@edcross.com and write the word license in the subject line, and we'll shoot that over to you, and that'll have some links in it as well. The good news here, if there is any, is that we are in very good company because California is one of the very few states that did not have a debt collection licensing requirement until now. So please don't shoot the messenger. This is my news of the day, and I wanted all of you to know it. I hope you have a happy, healthy, and safe 2022. And if we can help you in any way, please let us know. Thank you. God bless and take care.